Good afternoon, ladies and gentlemen. Welcome to this SIAC webinar on techniques, tips, and strategies for the effective management of international construction disputes. My name is Perry, and I am pleased to be your MC this afternoon. Thank you all for taking the time to join us to discuss strategic considerations and tools and techniques that may be utilized for the efficient resolution of cross-border construction disputes. We will begin with an opening address by Ms. Lim Seok Hui, CEO of SIAC. Ms. Lim, please.
Thank you, Perry. Good afternoon, good evening, good morning, everyone. We are delighted to be a part of Dubai Arbitration Week and to be hosting this webinar. I'd like to start by thanking our court president, Gary Bourne, court member, Tom Schneider, and our distinguished panelists for your participation and support. I would also like to thank each and every one of you for taking the time to join us this afternoon. I'd like to spend a few minutes to tell you a little bit about SIAC. We are where we are today because of Singapore. So I'd like to start by giving you a quick overview of the international arbitration ecosystem here. We have modern and progressive arbitration laws that are regularly updated to align with global best practices. We have a trusted legal system. The courts are maximally supportive and minimally and practice minimal intervention in international arbitration. The judiciary is comprised of highly respected local and international jurists. In terms of physical infrastructure, we have Maxwell Chambers, which has state-of-the-art hearing facilities. In these times, they are offering virtual hearing services as well as hybrid hearings. Singapore is among the top 3 arbitral seats in the world. That said, parties don't need to choose Singapore as a seat, although in practice, despite the delocalization of the seat in our 2016 rules, Singapore remains a very popular seat amongst parties. SIAC is among the top 3 most preferred arbitral institutions in the world, and that makes us the leading arbitral institution in Asia. But SIAC is not a Singaporean or an Asian arbitral institution. We are a global arbitral institution. And you can see that from our top 10 foreign users. The UAE has been among our top 10 foreign users for some time now. And in addition to that, we have India, China, the US, UK, European parties from Germany, Switzerland, France, Northeast Asian parties from Japan and Korea, and other Asian jurisdictions. In the last 5 years, parties from over 100 jurisdictions have arbitrated at SIAC. The total sum in dispute in the last 5 years has exceeded $35 billion. Each year, we see on average parties from about 60 jurisdictions. We are a popular choice because of our reputation for neutrality, independence, integrity, efficiency, transparency, and stability. Over 80% of our cases are international, and many have no connection to Singapore or Asia. Let me turn now quickly to the people, the cornerstone of SIAC. Our board of directors is comprised of corporate and legal experts and is chaired by Davinder Singh, who is one of Asia's most accomplished litigation lawyers. Our Court of Arbitration is led by Gary Bourne as our president, and Gary needs no introduction whatsoever. Our court members come from various common and civil law jurisdictions, and they oversee case management at SIAC, which is performed by our secretariat. We also have a multinational team of talented lawyers, experienced lawyers in the secretariat, and they are qualified in, apart from Singapore, the US, UK, Canada, India, China, the Philippines, Malaysia, and other jurisdictions. We are able to administer arbitrations in languages other than English, and we have administered bilingual arbitrations. Our panel of arbitrators, we have over 500 arbitrators from 40 jurisdictions, and over 100 arbitrators out of these 500 or so arbitrators are experienced in energy and EPC disputes and are often involved in our construction cases. We also have an active and dynamic users council with whom we work on big projects such as our ongoing rules revision. Today's topic focuses on international construction disputes, which constitute roughly 15% of SIAC's cases. As we know, construction projects are typically complex, long-term, high-value, and often involve multiple parties from various jurisdictions. The SIAC rules have a number of time and cost savings mechanisms to facilitate the efficient, expert, and enforceable resolution of complex multi-party, multi-contract, and multi-jurisdictional disputes. These include the emergency arbitration provisions, expedited procedure, early dismissal, consolidation, joinder, as well as the arbitration, mediation, arbitration, or ARP-MED-ARP protocol. I don't have time today to go into these in detail. They will be the subject of future webinars. Many of you have asked what SIAC has done and is doing during the pandemic. We have stayed fully operational. In fact, this is our busiest year ever, and we have experienced strong caseload growth notwithstanding the pandemic. We've released an SIAC guide on virtual hearings. We've handled about 16 emergency arbitrations this year alone, and many of the emergency arbitrator hearings went virtual. We have stayed connected to our users through webinars and through online training programs. In addition to that, we have a live chat feature on our website where users can chat to us and get your questions answered in real time with someone from SIAC. And as I mentioned earlier, we have embarked on an important initiative, the rules revision process. And we invite, as always, comments, suggestions, and feedback from you, our users, as we amend our rules and go through this project once again. Last time round, we had over 1,000 comments from users all over the world. So we look forward to working with each of you on this and to a long-term collaboration to our users from the UAE and the Middle East. Thank you.
Thank you, Siac for that wonderful opening. Let me now introduce the panel. The panelists for today are Mr. Thomas R. Snyder, member of the SIAC Court of Arbitration and partner and head of arbitration at Al Tamimi & Company. Tom is based in Al Tamimi's Dubai office, and his experience covers a wide range of industries, sectors, and types of disputes, including construction disputes. Also from Al Tamimi & Company is Dr. Hassan Arab, who is a partner and the regional head of dispute resolution. Hassan has extensive experience as an arbitrator and provides expert opinions on UAE laws. We also have Mr. Lim Dao Kai, partner at Ellen & Glettel LLP. Dao Kai is the deputy head of the firm's construction and engineering practice, and he undertakes a wide range of contentious work in those areas. Next, I'd like to introduce Mr. Derek Nelson, partner at HKA. Derek is a chartered quantity surveyor with 40 years of construction and engineering experience across a range of sectors. Last but not least, we have Ms. Erin Miller-Rankin, partner at Freshfields Brockhouse Deringer. Erin has specific expertise of complex international arbitrations in the oil and gas, power, mining, and transportation sectors. Moderating the session is Mr. Gary Bourne, President of the SIAC Court of Arbitration and Chair of the International Arbitration Practice Group at Wilmer, Cutler, Pickering, Hale, and Dorr, LLP. Gary is one of the world's preeminent authorities on international arbitration and international litigation. A warm welcome for our moderator and panelists, please.
Thank you. Thank you so much, Perry, for those gracious introductions. Everybody on the panel, myself excluded, fully deserves all that praise. And I'd like to thank also both the panelists and most importantly, the attendees for taking time this morning, this afternoon, as the case may be, for being with us. The topic today is tips and techniques in international construction arbitration. Most of what we'll say will have direct relevance. Most of what the panelists will say will have direct relevance to cross-border construction disputes, but it will also have relevance to other types of arbitration. Many of the lessons that have been learned and pioneered, developed in international construction dispute resolution apply to other types of disputes and equally learn from other types of disputes. I'd like to begin in a sense with why we're here virtually, and have our panelists talk about COVID and how it has affected dispute resolution with an eye towards, and perhaps a little over optimistically, but an eye towards post-COVID times as well. Perhaps, Tom, we can kick off with you. Can you address your experience in COVID times with international construction arbitrations, hearings in particular? I think you're on mute.
Sorry about that. Yeah, happy to. And then I think I'll turn it over to Hassan. I think
I believe I'm the one who assigned to cover this topic.
Yeah.
However, I would welcome welcome my colleagues to interfere. First of all, many thanks for Siac for organizing this event. Many thanks for Gary actually to moderate this event. I'm quite honored to be part of the panel. I will not be going to cover the COVID from the merit side actually. While I'll focus more on the procedural side based on the experience we had during the COVID time. As an introduction, actually, COVID will not add any additional to the complexity of the construction disputes, because the construction disputes in the nature, it's a complex disputes with the technical issues, with a lot of things around the dispute. Yes, it will add some, or it will let us initiate some old principles we have in the laws. For example, the force majeure. It's been a debate whether it is the circumstance is equal to raise that principle again or not. Hardship, returning the parties to to make that like imbalance between them. I agree actually, and most of the courts around the world actually, they had different views with regards to the COVID. But my presentation today will limit to the experience we had during the COVID with regards to the procedures, not only in the construction disputes, but in arbitration overall. And I believe it was the right time for the arbitration to raise due to the flexibility in the rules, due to the flexibility with the laws and regulations. For example, in UAE, we were lucky to have the Arbitration Act, which been launched 2 years back. And because it has actually a provisions dealing with the e-hearings and the technical issues of conducting the hearings virtually, we were lucky actually to have those provisions in order to use them in the arbitration. Similar actually with the court, we had the experience, unlike the some countries around us, because we had the platform and the technology was introduced long time back. the courts were able to run the hearings immediately when the COVID appears, and still we are attending in the virtual basis before the courts. And I believe this will be the norm even after the COVID.
I think even after lockdown eases, we'll still be doing virtual hearings.
Still we are attending in a virtual basis. Yes, there are actually, I'll come back to that point about the advantages and disadvantages, but it seems to me that it will be the norm. In terms of the cost, in terms of the time, I believe it's a good way to appear before the court. And this is what we noticed even in the arbitration. Personally, I had the opportunity to appear before a tribunal in a virtual way. There was challenges actually with the time zone because the parties were sitting in different places. But again, the institutions, they did a good way to maintain bringing the parties to the hearings. E-bundling, actually, the e-documents was very good. The technology, the program that you used to run the hearings was perfect. However, actually, when we come to the whether this will be the norm in the arbitration or not, yes, I agree that there was an effect, especially in the if we talk about the construction disputes and the time management. There was actually the cost effects because we don't need to travel anymore. The witnesses will submit their statement virtually. But based on what I noticed and what I heard actually from some of the practitioners as well, that having the hybrid, the mix between attending in person and attending virtually, it's a need, because you cannot basically always have, especially when it comes to the witnesses, what the practitioners noticed, that the witnesses, they are more relaxed in order to submit their statement. The counsel who are doing the advocacy, they found it difficulties to raise the question virtually. They prefer to have the witnesses in person.
How did it work in, Hassan, how did it work in your hearing with the virtual cross-examination? Did you have the impression that it was effective, or that counsel wasn't really able to ask questions well?
The question is fine actually, but sometimes when it comes to show the documents to the witness, it's quite difficult actually. Sometimes the accent of the counsel when it is in person is different than using the technologies. And you know the issues that are raising out of the technologies sometimes. I don't want to be very negative. It's a good way actually, and this we have to use ourselves to this norm. But the comments is coming from the practitioner. Personally, even in litigation side, when I'm attending before the court, it's very good actually in the civil law jurisdiction. Most of the cases before the court, it's a way of exchanging the pleading, which will not require a lot of efforts. But when it comes to the verbal pleading before the Court of Cassation, for example, I found it very difficult. I found it very difficult because the body language is very important. You would like to see the impression of the panel who are sitting in front of you, whether they understand the points that you are raising or not. So overall, I can see that this will be the norm. However, I'm with the idea of having hybrid, the mix, when it's required to have in-person hearing, it should be in person, especially with the witnesses. But the issue, and this is, I will leave it to the panel also to put their feedback, that most of the arbitration institutions now, they are amending their rules in order to give the tribunal more power towards encouraging the parties to accept having the virtual hearings. Not only this, even in the arbitration federal law of UAE, for example, we have Article 35, which gives the tribunal a massive power to conduct the virtual hearings. And I believe it will lead to an issues in the future. For example, if one of the parties is insisting to have in-person and the other party is happy to have a virtual hearing, how the tribunal will deal with this, how the court will deal with this, although the legislation give a massive power to the tribunal. This is overall actually my experience about the COVID and the e-hearings.
That's very helpful, Hassan. Dr. I think you had some observations as well about virtual hearings, about technology in the age of the virus.
Yeah, thanks, Gary. I think I would just like to echo a few points that Hassan made. I mean, obviously, first, I think virtual hearing has virtually become the norm. And from where we are situated in Singapore, I think one of the difficulties we face with virtual hearings is, if you have parties from all over the world, and really time zone plays a part, right? Because I had a matter where we had somebody in Australia, somebody in London, somebody in Singapore. I mean, finding sitting hours which are fair to all parties is a challenge. So that's my first point. The second is really, and this relates to the point that Hassan raised, is the difficulty in posing questions to the witnesses. My experience is that much of this has got to do with, especially when you refer documents to the witness. And my experience is that I think much discipline and organization must be now put, in organizing your documents electronically, to facilitate, looking for these documents, because otherwise that's going to be a struggle, especially, in arbitrating construction disputes where you refer to a lot of documents. So really organization is key of the documents electronically. That's the second point I'd like to raise.
How is a practical matter were documents displayed? Did you use an outside vendor, an external vendor, or did you try screen sharing?
So we've done screen sharing. So that would really speed up the process. I mean, if you have perhaps fellow counsel actually pull up the documents that we referred to, we find that most helpful, right? But I think liberty has still got to be given to the witness to actually scroll up and down the documents to put the documents in context, because that's one of the other difficulties I experienced during the hearing, which is that a witness is shown a particular page of a document on screen, but he should be given the liberty to actually scroll up and down to put the documents in context, because that's, in a physical hearing, that's a latitude he's given. And I think such latitude should also be made available to the witness in the virtual hearing, right?
Yeah,
Just
I think I interrupted you after point 2.
Yeah. And I think the third point is interpretation. I mean, again, this is something that I think most of us have been able to overcome. When a witness requires interpretation, who's going to do the interpreting? Where's the interpreter going to sit? How's that going to be done? I think that's something that has to be considered. But again, in my experience, that's something that, whether in the courts or arbitration, we've all managed to overcome. Right. Again, the difficulty for the interpreters again when reference is being made to documents. So again, that's something that the interpreter has got to be familiar with as well, the reference to documents. But otherwise, undertaking interpretation remotely via Zoom or whatever other platform, I mean that has not proven to be insurmountable.
Yeah. Just very quickly before we move on, will these virtual hearing techniques survive the pandemic? If the vaccines work and we can all go back to being together in person, will we continue to have Zoom or Teams hearings, or will we in fact go back to having in-person hearings?
My sense that virtual hearings will still be an option, especially, the undeniable truth is that, having parties fly into a particular place, especially when 3-member tribunals are concerned, I mean, can be costly, right? So my sense is that virtual hearing will still be an option. But I think ultimately, as Hassan alluded to, it depends on the tribunal as well, the laws applicable. But that's my sense; it will still be an option, because this pandemic has shown that it is viable and it's a viable option.
As we move on to other topics, which I think we ought to do at this point, anyone who has additional observations about virtual hearings ought to feel free to add. Let's move on to multi-parte, multi-contract disputes. They're common in many fields. They're especially common in construction arbitrations, construction disputes. Tom, This time, hopefully, I am correct with my with my rota of speakers. Your thoughts on this?
Thanks very much, Gary. And good afternoon, everyone. First, let me say how happy I am, how pleased I am to see SIAC taking part in Dubai Arbitration Week this year. Like so many other events, the week has gone virtual. Yesterday was the first day, so we're still sort of feeling our way through. There have been a couple of in-person events, socially distanced, of course. But it's good to see SIAC take part, and we hope next year to have another event in person. Before moving to multi-party arbitration, if I just very briefly touch on the last topic, and that sort of share my 2 cents. The way I see this playing out, once we get past the pandemic, once the vaccine comes into play, is, I think it will very much be the case, very much be the default, that when you're talking about case management conferences and jurisdictional hearings and other hearings where it's primarily legal argument, I think the default will be virtual hearings with the occasional in-person hearing, especially in big ticket disputes. My view is, though, when you get to the merits hearings, I think we'll largely be going back to in-person hearings. And I say that for a couple of reasons. Number one, I think it's just sort of in our DNA as arbitration lawyers. We like to jump on airplanes, we like to go places, and we like to fight it out in person. I think to some extent, and others may disagree with this, but I think it will be client-driven to some extent. We've got one case where we have postponed the hearing specifically because I think each side wants to put the CEO of the other party through the pain of having to sit in person in a room full of lawyers and arbitrators. So that's my own view. CMCs and jurisdictional hearings primarily virtual, merits, especially big ticket cases, primarily in person. But moving away from that and getting into the topic I'm supposed to talk about is multi-party arbitration. And I think like Hassan, I'm going to focus more on the procedural side than the substantive side of this, and sort of start with a broad overview and quickly focus in on consolidation in particular. So of course, one of the features of a typical construction dispute is that A, you have a large number of parties involved, and B, you have several interrelated contracts at play. In a typical construction dispute, you'll have the employer who enters into the main contract with the contractor, and then typically the contractor will subcontract some of the work out, maybe to one subcontractor, maybe to multiple subcontractors, and some of the subcontractors themselves will have additional subcontracts on down the line. On the periphery, you'll have others, you'll have an engineer, you'll have suppliers, and so on and so forth. And because of these interrelated parties, these interrelated contracts, changes that affect the main contract will inevitably have a ripple effect on the subcontractors as well. So a variation that's requested by the employer might affect the scope of some of the subcontractors' work. On the flip side, a delay in performance by the subcontractor may result in a delay in the overall project. But despite these interrelationships, the fact of the matter is that typically these are all separate contracts. The main contract is a separate agreement from the subcontract. And so as a result, generally speaking, there are exceptions, but generally speaking, there's typically no direct liability, say, between the employer and a subcontractor. Broadly speaking, the contractor is responsible for the acts or defaults of the subcontractor in most cases. So that's liability. The same is true in terms of the dispute resolution clauses. Typically, there's no sort of overarching dispute resolution clause that allows different disputes in sort of this constellation of parties and contracts to resolve all the disputes in one forum. There are ways around this, of course. You can have umbrella arbitration agreements that relate to the various contracts at play. You can have identical arbitration clauses that expressly provide for multi-party arbitration in the various agreements. But I think, certainly in my experience, this is uncommon. I think, especially here in the region, you just don't see a lot of this coordination in terms of the dispute resolution clauses. You may occasionally see arbitration clauses that are compatible with one another, but typically you don't see sort of a careful, comprehensive attempt to coordinate all these clauses. And so what that typically means in practice is that if one of the parties or some of the parties want to resolve their disputes in one forum, they have to look to the rules of the relevant arbitral institution to see if there are options available for multi-party arbitration. And there are various mechanisms, of course, that can be used. The two most common ones probably are joinder of additional parties and consolidation of multiple arbitrations. The arbitral rules of most of the major arbitral institutions have provisions on joinder and or consolidation. The SIAC does, of course, and consolidation applications are not uncommon in SIAC cases. Since the SIAC introduced provisions on joinder and consolidation in the 2016 rules, to date, there have been 235 consolidation applications made to the SIAC, out of which 128 were granted. So about 60% of the applications to consolidate arbitrations have been granted. So 60% is a pretty good number. It's more than half. But it's not 90%, it's not 100%. It suggests that certain criteria have to be met in order for consolidation to take place. And I think it's interesting to look at the SIAC rules on consolidation, which are found in Rule 8 of the SIAC rules. Arguably, the SIAC has one of the more permissive regimes for consolidation, and I would say probably one of the more detailed and comprehensive regimes as well. If you have an SIAC case, and I could be talking about other arbitral institutions as well. Like I said, most of the major arbitral institutions have these rules, but I think the SIAC rules in particular are interesting. If you want to consolidate a case at the consolidate multiple cases at the SIAC, you have to meet one of three conditions. And the third condition, which I'll get to in a minute, has its own three sub-conditions. The first condition is pretty straightforward, and you find this condition in just about every set of rules, and that is if all the parties have agreed to consolidation. If all the parties agree, it's pretty straightforward. The second condition that can be met is if all the claims in the arbitration are made under the same arbitration agreement. Here again, you find this in most of the rules of the major arbitral institutions, again, pretty straightforward. The third condition, and again, you don't have to meet all these conditions, it's one of the three, but the third condition I think is probably the most interesting one, and that is if the arbitration agreements are compatible with one another. Now, compatibility is not defined in the rules, and so this is subject to some debate. But I think generally speaking, to find arbitration clauses to be compatible with one another, you probably have to have the same institutional rules. You probably have to have the same seat of arbitration. Arguably, you have to have the same number of arbitrators or method for selecting the arbitrators. If the clauses are silent about that, that'll be addressed in the rules. And then, maybe other features as well. Language might be an issue that's open to debate. But if the application for consolidation is made before the tribunal is formed, the SIAC court will determine the consolidation application. If the application is made after the tribunals have been formed, it'll be made by the tribunals. But not only does the agreement have to be compatible, it has to meet one of three subconditions to that. It's got to be compatible and arise out of the same legal relationship, Or, and I think this is the most interesting one for present purposes and probably the one most applicable to construction disputes. The agreements have to be compatible and the disputes have to arise out of contracts consisting of a principal contract and its ancillary contracts. So I think there, at least arguably, if you've got a construction dispute with compatible arbitration agreements, there is a strong argument to be made that both the contract and the subcontract would meet that sub-criterion. The last one, probably not relevant to construction disputes, although it could be in some cases, is if the disputes arise out of the same transaction or series of transactions. What's interesting, I think, about that sort of sub-provision is that while it refers to same or series of transactions, it doesn't make a reference to related transactions. That is a point that's been picked up on in the new LCIA rules on consolidation. They now have that provision relating to related transactions. So I think probably a lot more that could be said about this, but let me stop there and turn the floor back over.
Thanks so much, Tom. There's lots that could be said. We could have separate webinars on each one of these various topics, but that was very thorough. One commercial advertisement, or alternatively request for collaboration. We're in the midst at SIC of the revisions to our current set of commercial arbitration rules, the 2016 SIC arbitration rules. We're consulting widely for feedback on how our current rules work. And if anyone has suggestions, observations, complaints, by all means participate in that process. You can find out how to do so on our website, and we would actively encourage everyone to take part in that process. Because time is short, let's move on. And speaking of time, international arbitration, like other types of dispute resolution, inevitably takes a while, whether it's in person or virtual. Parties need an opportunity to be heard, even if only on Zoom. While the arbitration goes forward, though, the world does as well, and things may change, requiring one or both parties to try and either preserve the status quo or to obtain some sort of protection against things that might either endanger the arbitration or endanger the efficacy of final relief that the tribunal might, should they prevail, grant. Aaron, help us on the topic of interim relief, emergency arbitration. How does one do that in international construction arbitration with a particular focus on SIC rules?
Sure. Well, I think, as a preliminary matter, 2020 has really changed how we think about emergency and urgent, with everything being urgent emergency crisis, from the pandemic, the economy, the US elections. We even have toilet paper emergencies in some places. But emergency arbitrations are for actual emergencies. So it's when you have an urgent matter that can't wait for a tribunal to be constituted. So this urgency has to be objectively real, and it has to be sustained throughout the proceedings. So an example where this comes up a lot in construction arbitrations is with bond calls. So in terms of having it and then having it sustained, it would be urgent if you had a bond call. If at the same time you were applying to courts for relief and you got relief, you lose your urgency in the emergency arbitration context. These proceedings have very strict time limits. It's a sprint. It's actually helpful for everybody to be in lockdown during them because your team can't run away and go have fun. Tips for success in terms of doing them, given the time pressure, and to have an emergency arbitrator, you basically need somebody who can clear their desk for a couple of weeks effectively. You should call the institution while you're preparing it so that they can do the running around and finding somebody. One of my ones that I had in the middle of the first lockdown, we had somebody appointed within hours and a freezing order a few hours later, a temporary one. So that was super efficient when nothing else was really working efficiently.
Those calls, I can report from SIC's perspective, inevitably come at around 6 or 7 o'clock, 6 or 7 p.m. on Friday. The registrar's office, Delphine Ho and Kevin Nash, are well experienced with having to appoint in those circumstances. But if parties could find a way to make things not happen on a Friday, I know that Kevin would appreciate it.
I'm sure in the Middle East, people put things in on Christmas Eve. So I think that you want to make your request as comprehensive as you can when you're making a request. Obviously, for all institutions, you need to pay. You need to make your clients understand that the money has to hit the bank for things to go forward. But as the proceedings are really compressed, you do want to make sure that you are comprehensive. Do bear in mind that you can get status quo freezing orders right away while the emergency proceedings are pending in some cases. So you need to remember to actually request that as opposed to the more longer term relief that you would want.
So Erin, this is even before the other side has, in a sense, responded on your real application, the underlying request for interim relief. You can get a freezing order immediately.
You can. Usually there is a requirement that the other party has to be at least notified. So it's not truly ex parte in that sense, as they have to be notified that the proceedings are on foot. Normally they would be given an extraordinarily short amount of time to say anything. And then you can, in my last one, it was a 24-hour temporary freezing order, which was then extended for the balance of the emergency arbitration proceedings. But if you're dealing with something like a bond call, you want that, you need that.
Yeah.
So the requirements differ in terms of when you have to start the actual arbitration. SIAC says that you have to start the actual arbitration when you file. Within the ICC, it's 10 days later. So you're preparing a lot of things at the same time. Of course, the tribunal in the actual arbitration can review the award. Some institutions allow you to opt out of emergency arbitrator proceedings. Some do not. It will be interesting to me after this pandemic, where there seems to be such a rash of these proceedings, whether that actually is a factor in arbitration rules that people choose, whether they can opt out of this or make sure that people can't opt out of it going forward. Main problem with emergency arbitration awards, of course, is enforceability and whether they're going to be viewed as final awards and where you need to enforce. So some places, Singapore, Netherlands, Hong Kong, have adjusted the national arbitration laws to allow these to be enforced, but that doesn't help you if you're seated in Singapore and you need to enforce somewhere else that doesn't recognize them. Interim measures, which is what you usually ask for if you have a problem after an arbitration starts, has the same thing. And Gary, as you were saying, interim measures are those that are, aimed at preserving the status quo, taking or not taking certain action, preserving assets and preserving evidence. It's important to always check the national laws in terms of whether they define interim measures differently, because that's, the common definition, but it is defined differently in some places. There also might be a requirement to specifically opt in and empower your tribunal to give you provisional or interim measures. The general test, though, when looking at it is whether this is required to prevent harm that damages can't fix. So it's a balancing exercise. And you also look at whether the underlying claim has a reasonable possibility of success. Again, urgency is a factor. So, a good way to lose an interim measures application is to take your sweet time before making it. You would want to make it promptly once you have what you say is an emergency. In terms of the considerations, it's important to look at these, that you hit them when you're applying for interim measures. Is the relief that you're asking for available at the seat? Are you asking for something that's too broad? Can you narrow it and kind of persuade the tribunal that it's not really a big deal what I'm asking for, just a little favor? What order can the tribunal give that will have the desired effect? So what is it that you need and what is it that they can do? You want to avoid appearing as though you're making a purely tactical move. Most sophisticated tribunals will see through that, and it doesn't matter if you've got the best reasons on earth, the other side will probably say it's purely tactical anyway. What's the duration of the relief that you need? And is there any concomitant security that you're going to put forward to protect? So in construction, the most common ones that I see are stopping bond calls as the favorite. And in the Middle East, I'm sure Tom and Hassan have probably seen the same thing. You know, pandemic hit, everybody took out the, you know, the financial crisis handbook and started calling bonds. You'd also have ones relating to preserving evidence. So this can pertain to documents of a contractor, like if you've been terminated and shut out of sight and you want your documents preserved. Or if you have a concern that the counterparty is going to destroy their own documents. Preserving property, such as if there's equipment that's allegedly defective before they sell it for scrap, if you would want to have it looked at by an independent expert if there's going to be a dispute over it. Asking for an inspection to have a record of the works. So again, this is often in a termination context if you want to have access for that, or if the works are about to be covered up by a follow-on contractor. Freezing assets if dissipation is a concern. Ordering interim payment can be pretty difficult to make out urgency on that, but sometimes you can. And security for costs awards are other things that you can ask for. And that's, I find particularly pronounced now with insolvency as being an issue, as well as third-party funders and people being afraid of hit and run proceedings.
That's very comprehensive and very helpful, Aaron. Hassan, can we come back to you for just a moment, a view from your perspective?
Yeah, many thanks, Gary. Actually, I will, with regards to the emergency arbitration, I never had the experience in our region, actually. However, I know that the institutions here in the region, especially in Dubai, let's say the IFC, LCIA, they have the provision dealing with the emergency arbitrator. I'm sure that DIAC very soon they will amend their rules to include even the emergency arbitrator. I share actually the concern raised by Aaron with regards to the enforceability, especially that we don't have any provision within the federal law dealing with the emergency arbitrator. The good thing, the positive thing, and since we are talking about UAE and the webinars happening during the arbitration week in Dubai, that we never had the provision to give the tribunal powers to order the interim relief previously before the new law. In 2018, when we introduced the new law, there was a provision giving the tribunal this power. And the good thing, the positive thing, that we had two decisions by the Dubai Court of Cassation in 2019 and 2020, not only giving the tribunal this power, but even to return back the power, to cancel the power, you cannot have it through the court. If you obtain the order with the tribunal, you have to go back to the tribunal in order to cancel it. The court cannot interfere, which is a good step, I believe, towards being friendly with the arbitration and providing the tribunal with more powers.
That's very helpful, and I can certainly say from my own experience, both as counsel and at SIC, emergency arbitration has really been the flavor of the last few months. COVID has brought out, underscored the need for expedited interim measures. Aaron, can we come back to you on another related topic, bifurcation? Is that bifurcation or trifurcation of arbitral proceedings? What is that? Is it done frequently? Should it be done more or less frequently?
Yeah, there is a definitional issue there. So the dictionary definition, I think, means dividing something in two. Of course, in practice, proceedings can be divided up many different ways. You know, sometimes basically it's almost inevitable to have bifurcated or split proceedings. If you have a question, for example, about what's the applicable law, you need to hear that first. You can't have somebody plead every potential law. Joinder would be another one. Language of the arbitration, of course, urgent measures, you know, and Calderbank offers. So cases where the law and allows, or the parties have agreed that the tribunal has to issue its award on the merits before looking at costs. You know, there are other common but less mandatory splits. You know, the traditional ones were always liability and quantum or jurisdiction and merits. But other ones that we see a lot, jurisdiction, there is the jurisdictional ones, but looking at discrete claims or points of law can also be common. One of the things that you have to be mindful of is what form of decision are you going to come out of this with, and is it going to be enforceable? So if you've got an interim order, can you enforce that internationally? If you're issuing a partial award, then you have a downside of potentially being able to challenge it in state courts while you have proceedings ongoing in the arbitration, meaning parties are fighting on two fronts and potentially disrupting the rest of the arbitration. Of course, the benefit, if you have an award, can relate to enforcing it. Things that tribunals have to look at is whether res judicata is going to be a concern with non-final awards if you're bifurcating proceedings. And that can vary with the different applicable laws. So there's not one easy answer. It's something that has to be reviewed carefully before you're asking for something that might actually do you more harm than good. There is a genuine risk, I think, if the bifurcation, the way that it's split, results in claims that are intermingled or inextricable from one another. There can be inefficiency if evidence has to be heard twice, but there can be a greater harm if you're not hearing all the evidence that you need when deciding part of it. Efficiency is usually the reasons why people say to do this, but I think efficiency arguments on both sides are overblown. The people who are saying, oh, this is going to make everything perfect and way cheaper, usually not accurate. People who are saying it's going to make everything way more expensive, also usually not accurate. I think the best cases in construction are when you can have something that are making issues moot, dealing with discrete issues. For example, does a limitation of liability clause bite on this point? If the answer is yes, do you really want to stay in the fight when you know you're only getting that amount of money? Maybe not, go away, settle. Clarifying the scope of other issues is also helpful. And of course, if it gets rid of the entire dispute by a negative decision on something like jurisdiction. Conversely, if there's anything that requires intensive fact-finding, especially intensive fact-finding that has to be then replicated through further phases, it's an argument against. But some of the mega case disputes, not just a regular run-of-the-mill construction disputes, but some of the enormous ones that are otherwise going to require months of hearing, virtually or in person, I think the only way that people can survive it is to split it into some sort of chunks.
That's very interesting, Erin. Is bifurcation more or less frequently used, or used just the same amount during COVID? Does the use of virtual hearings, Zoom hearings, impact whether or not a tribunal bifurcates, or is it just a wash?
My experience is that it isn't, but it should be. I think people are still trying to feel their way around and don't have enough experience with maybe how tiring sitting through virtual hearings are to know that they should try and take this in stages a bit.
Yeah, I mean, it's also important to remember that bifurcation suggests that the tribunal will make some sort of decision, an award, an order, something that resolves maybe finally, maybe not quite finally, some element of the case. Another aspect of scheduling or segmenting the proceedings isn't so much bifurcation as just how one constructs hearings, schedules hearings. When we have in-person hearings, almost inevitably, everybody comes to a single physical location, often from other places. And while you're all there, it makes no sense not to use the available time. And so we inevitably have concentrated hearings. Everybody is in town for 5 days and you have hearings 8-9 hours a day, precisely because everybody is there physically. With Zoom hearings, the world changes all of a sudden. You can have 3 hours of hearing one day and then stop because you're done with that witness. The next day you can have 8 hours if you can survive Zoom fatigue. The next day, a couple hours. But the technology does give us ways to segment the hearings as well as the proceedings. But Derek, your perspective, and I know this will be deeply into the nitty-gritty of construction arbitration, but your perspective on both bifurcation and segmenting of hearings.
I think certainly as far as, well, my experience for matters that have been bifurcated, from an expert's perspective dealing with quantum, it narrows what you have to consider tremendously. So you already have, in essence, a finding on fact or liability, and therefore what you're looking to do is to quantify the effects of that. So for party-appointed experts, you don't have the same range of assumed facts, for instance, therefore the same range of opinion attaching to how the tribunal may find on certain matters. So you narrow that tremendously, and I think that has, in my experience, allowed certainly quantum experts to come together. If you can agree approach and methodology and what you're actually basing those valuations on, then getting to an agreed position, a joint statement with very little diversity in it tends to be much easier. And I think that certainly assists the tribunal. But because you've removed that range of options, you can actually focus on those areas that then actually need to be quantified in the context of a finding that's already there. And I think that has to assist the process. But that only makes sense, obviously, in certain cases.
So from your perspective and from the expert's perspective, bifurcation, segmentation can produce some efficiencies.
Oh, absolutely. Because I say, if you have party-appointed experts who are having to look at different contentions from different parties, then in order to assist the tribunal, you need to be able to be in a position to set out, in essence, a valuation matrix for each one of those. And you may have multiple issues within a particular aspect of one of those valuation points that you then end up with 2 or 3 alternative opinions to a given matter. And I've seen construction arbitrations, particularly that are large, complex projects, where when you get to a point of the joint statement, you end up with this huge schedule of alternatives depending on findings of X, Y, and Z. And that can get very complex.
There's been some interesting academic work done, mostly in the context of investment arbitrations, about the ultimate impact of bifurcation on time and cost that the arbitration take. I at least found some of the findings a little counterintuitive, a little surprising. If I understand them, it is that bifurcation actually adds fairly significantly, irrespective of how the particular issue is resolved, to the overall time and cost of the proceeding. It's work done by Professor Susan Frank in the United States. And it is focused on investment arbitration, which may raise peculiar issues because of the nature of jurisdictional objections. But nonetheless, it does provide food for thought as one tries to decide how useful, how not useful bifurcation is. Relatedly, and Dao-Kai, let me move back to you for just a moment. Agreed issues, lists of issues, which in a way serve a similar purpose to bifurcation. Agreed lists of issues, Scott schedules. What is your experience with them? How do they work, especially in construction arbitration?
Thanks, Gary. I think from my perspective, I would view, a list of issues or even an agreed list of issues as a very important tool, I think, to manage time and cost that are expended in resolving disputes in arbitration, right? And I say this because I think a list of issues serves to crystallize, what a tribunal has to determine at the end of the day, right? I mean, ordinarily, I think an arbitration, the substantive arbitration process commences with, I think, the claimant, putting in its statement of case or memorial, followed by, the respondent, submitting its statement of defense or response memorial. I think there's much to say in putting together a list of issues as soon as the issues between the parties have been crystallized. However, I note that, not all the institutional rules actually provide for a list of issues to be framed. But I would recommend that this be done as soon as possible. And
how do you deal with parties who just won't agree on anything? What if each one comes up with their own list of issues? Does it really save time? Does it really clarify matters for the tribunal to keep pushing to get an agreed list of issues?
I think ultimately, the parties' cases are crystallized in whatever they're submitted. And really, again, this is a matter of case management. I think there's much merits in a tribunal, even in these circumstances, to draw up, what the list of issues should be, right, despite the parties' disagreement, and include in the terms of reference for determination. Because really, it's a list of issues like that really focuses, not only parties' minds, but and also assists the tribunal in really, having a reference point as to what has to be determined in the arbitration, right? And and one of the tools, borne out, in the resolution of construction disputes is what's referred to as a Scott schedule, right? A Scott schedule, essentially sets out in the tabular form, usually in A4 paper or A3 paper, in a landscape format. In a tabular form, the issues, that are in dispute, that are in play between the parties in the arbitration. So in construction disputes, I think oftentimes you deal with many variation claims, many delay claims, even many defects claims. A Scott schedule helps to set up and particularize and itemize, each and every one of these disputed items, whether they're defects, variations, or delay events, and then set out, column by column first, the claimant's position on each of the issues, followed by the respondent's position, and finally a column for the tribunal to determine. Ultimately, this is a collaborative document, right, to be circulated amongst the parties, but really it serves as a handy reference point for parties as well as the tribunal to have in hand to see, what's really in dispute and what has to be determined in the proceedings.
Tom, your thoughts on just the same topics?
So not too much more to add here. I agree with most of the points that have already been made. I think on the agreed list of issues, at least in my own practice, I think I probably recently have been seeing more instances where the parties don't agree or can't agree, whether that's there are good reasons for that or if it's more tactics than anything else. I think nevertheless it's a useful exercise. It forces the parties to at least try to narrow down these issues, and if they disagree on what they are, at least to have to explain why. And I think when the tribunal ends up with two separate lists of issues, it's still nevertheless helpful because the tribunal sort of sees where each party's coming from. And I think a lot of times they can sort of see through that and have a sense as to which party is being more reasonable.
Disclosure, discovery, document control, Redfern and Stern schedules. Everybody seems to want to have their name attached to some sort of written submission in arbitration. But that point aside, can you talk to us about disclosure in international arbitration?
Right. I guess, documentation and document production, can be something, parties and tribunal can be bogged down by a lot, especially in construction disputes. I mean, I think we're all familiar that in construction disputes, we're dealing with voluminous amounts of documents. From the common law tradition where I'm from, a party is obliged to disclose not just the documents that he wants to rely on, but also, documents that are adverse to his case. Of course, I understand in the civil law tradition, essentially a party only needs to disclose documents that he wants to rely on. Right, but in reality, insofar as international arbitrations are concerned, I think most parties usually agree on the IBA rules on taking of evidence to guide them on documents production. I think the IBA rules provides a middle ground. After parties produce the documents that they want to rely on, I think a process for document production requests is laid out. And I think that's where the Redfern schedule comes up. Again, you know, the reference schedule is a table. It's a collaborative document. You know, it sets out, you know, item by item, you know, the document requests, you know, that each party wants to make, that the requesting party's justification for the request, followed in the next column by, you know, the respondent's reasons for objecting to the production of those documents, followed by a final column, you know, where the tribunal determines on each and every one of the document requests. You know, again, you know, the reference schedule is really a tool to really simplify and the process, to save time between having to flip across different submissions of parties to see what their respective positions are. So the reference schedule is really a comprehensive document, you know, which sets out, you know, each and every item that the party requests, documents that party is requesting for, as well as the respective parties' positions on why the documents sought should or should not be disclosed, and ultimately, you know, for the tribunal to determine, you know, in a final column whether a document should be produced.
Dakai, that's very interesting. The recently adopted or published were the Prague rules, supposedly on the efficient conduct of arbitral proceedings. Their approach to discovery is a little bit that it shouldn't happen. Discovery is a bad thing. In your experience, thinking back about the cases that you've been counsel in, that you've sat in as arbitrator, in what percentage of cases was discovery important? Or conversely, in what percentage of cases was discovery just modestly important or essentially irrelevant?
I think, you know, coming from the common law tradition that I am in, you know, and the amount of time that's actually spent, you know, in discovery, requests for discovery, and so on, you know, my experience really is that, you know, to the extent that a party is going to rely on a document and he discloses it, you know, usually, you know, that's sufficient to determine a case, because the reality is, if you're commencing proceedings hoping to find documents, my experience is that never turns out anything, right?
So you don't belong in Singapore, you belong in Prague, it seems to me.
I think Prague is the other extreme. I would say
Tom,
that.
Go ahead. Sorry, Dakai.
I mean, my experience, the reality is, you know, if especially a claimant puts a case together, he's going to put forth all the documents he could rely on. Similarly, a respondent in putting forth his defense will likewise put all the documents that he's going to rely on. You know, if you put forth a case or you put up a defense on which you don't have documents to back you up, chances are the discovery process is not going to help you. That has been my experience.
Interesting. Tom, do you live in Singapore or Prague or somewhere else?
Probably somewhere in between, maybe a whole nother city entirely. Look, I'm an American. Maybe Abu Dhabi, and I'll tell you why in just a minute. I'm an American lawyer, right? So unquestionably, I think there is a role for document production in international arbitration. I will say, though, to answer your question, Gary, probably in the vast majority of cases I've been involved in, document production has moved the ball forward slightly, but probably only inches. There have been a handful of cases where it has moved the ball forward fairly substantially. And I think really only one case that I can point to some years back, 10 years back now, where there was a silver bullet. And that was I think an unusual case because there were parallel litigation proceedings going on in the United States. And it was an example where we were able to get the document we wanted through the litigation proceedings in the US, and were able to connect the dots and establish that our opposing party in the arbitration had actually listed this document on its privilege log, when in fact it wasn't privileged at all and contained some pretty damning information. So that's been sort of a once in a career example. Most of the time it's only inching the ball forward, but I still think there's a role for it. I don't think you want to do away with it entirely. I do think more thought needs to be given as to how you can sort of streamline the document production process in international arbitration. And you know, again, as an American lawyer, what I'm about to say may border on heresy. But I think one way to do that is in the, you know, here, I know we have several people tuning in from the region, but we have quite a few outside the region. Here in the UAE, we actually have 3 arbitral regimes. We have the federal arbitration law, but then we have 2 sort of judicial free zones, the Dubai International Financial Center and the Abu Dhabi Global Market, and each of them have their own arbitration laws. And the ADGM, Abu Dhabi Global Market, has the ADGM Arbitration Center. They've issued some arbitration guidelines, which are effectively a set of rules that parties can use to administer their arbitrations. The ADGM Arbitration Center does not administer cases, it's more of a facility. But what's interesting about the ADGM arbitration guidelines is that they contain a provision in the section on documentary evidence that says when it comes to document production, a party can only request documents that it needs in order to discharge its own burden of proof. And it cannot request documents that go to supporting the counterparty's own claims. I think what happens in practice a lot, people sort of try to game the document production process and use it as an opportunity to point out shortcomings in the other side's case. But I think a move towards, or at least considering a move towards imposing a limitation that says you can only request documents that you need to discharge your burden of proof may help sort of rein the document production exercise in.
Interesting. One sometimes sees tribunals, usually civil law tribunals, adopting similar types of reasoning, even without the statutory provision to that effect. Aaron, this isn't scheduled, but your thoughts on document disclosure. Are you where Dao Kai is? Are you where Tom is? Or are you in your own universe?
I think that it is sometimes helpful. I think a good way to do away with it, though, is to put in the clause no disclosure. I have some clients that have done that, and that just obviates the whole thing. I think the amount that you usually get from it is totally all out of whack to the amount that it costs you to go through it, and it just isn't an area where tribunals seem to be really decisive or across the issues. The only thing that I think should happen, which isn't disclosure per se, and gives you a nice segue into what I believe is the next topic, is making sure that the experts all have the same information available to them when they're
interesting. So overall, and not wanting to generalize too much, a fairly disclosure skeptical audience, or set of remarks from the panelists. Perhaps we can take a poll at some point of the participants, the audience, the attendees, and see what their views on disclosure are. Before we do that, though, as Aaron has prefigured, let's turn from lawyers and disclosure to experts. Derek, can you lead off on joint expert reports, tribunal appointed experts with a particular focus on construction arbitration?
Sure. Perhaps if I take tribunal appointed experts first, and then we can work our way through to the back end of the procedure. So there has been an awful lot, to my mind, over the last maybe 5-6 years, where the proposition that a tribunal appointed expert somehow is better or more cost effective than party appointed experts within tribunals seems to have become a lot of noise surrounding that particular proposition. And then, if from my perspective, I naively, I guess, thought that procedures for the taking of certainly expert evidence were fairly settled. So we've had the IBA rules for 20 years. And then 2 years ago, 18 months ago, you end up with the Prague rules, to my mind, coming out of nowhere. So there's obviously been an underlying tension between this perception of common law and civil law approaches to particularly expert evidence. And from my perspective, there are a couple of oddities to that, simply because if I look at the Prague rules and I look at the IBA rules and I look at the CIR protocol, then there is a provision for tribunals to appoint their own expert at their discretion regardless. So had it been such an issue, it was an issue capable of being addressed by arbitrators under the IBA rules. I don't really understand the kind of the requirement for something completely different, and that something completely different, if it is the Prague rules, actually doesn't go to the extent of saying you cannot have party appointed experts. So I hear a lot of what I would just classify as noise around the idea that a tribunal appointed expert somehow is more efficient, takes away the issues that are perceived with independence and objectivity for party appointed experts. But from my perspective, I would certainly say it's not a panacea to those perceived woes of engaging party appointed experts. And if you had the chance to hear the keynote presentation yesterday by Professor Doug Jones, I think the paper that he issued yesterday is part of Dubai Arbitration Week, actually identifies the real issues with ensuring the tribunal achieve the greatest utility from expert evidence that is being offered to it. And I would suggest that my experience, I have been appointed as a tribunal expert. I have been on matters where parties have then, in effect, appointed shadow experts. So if the perception somehow is that having a tribunal appointed expert is more cost effective, which is one of the statements that I see written all over the place, that makes no sense to me, because you end up with 3 experts instead of 2. You just end up with 2 experts who stand in the shadows. And as a consequence of that, there is then a danger that they have no obligation to the tribunal. They are purely there as advisors to whoever appointed them. And they are not independent. They don't have to be objective. I don't know that that serves the process. If the concern about party appointed experts is one of independence, and obviously there are questions about their remuneration and how that may affect them and so on and such like, I actually think if I set America to one side, which is possibly never a great idea, then this idea that all party appointed experts are hired guns, that to me is a complete fallacy. I have come across experts whose behavior I believe is mistaken. I have never come across an expert that I actually believe is being paid to mislead, actively mislead a tribunal and promote a party's position when it's untenable. I think there's a difference between holding an opinion that is mistaken and having an opinion that is bought. So I think there is a lot of exaggeration in terms of the issue per se. And I would suggest that a lot of that can be managed by the tribunal by having early intervention. I am aware that one arbitration a couple of years ago, I know the 2 experts that were involved, they were brought in very early by the tribunal. Lawyers were in the room, tribunal, the experts, and basically the statement was made to them that you work for me, you work for the tribunal. This is what I require of you. So that obligation was set up very clearly, very early, and that early engagement with the expert sent them off to agree things like methodology, to agree the data sets that they were actually both going to have access to and both apply. If they were unable to do that, they had to come back and explain to the tribunal why. The biggest issue or complaint that I see is parties appoint experts, they send them off into the world with a package of documents which is not complete. They form an opinion based on one party's perception of what has happened. And then when they exchange reports and they present the opinion they genuinely hold on the basis of those assumed facts, that information, they then come back with another part of the story, another set of information and data that they had not had access to. And if they are being objective, then that should influence their opinion. And you end up with this gradual weaving towards a point where hopefully the experts come together towards an end of a process. Now, whether that's the most efficient approach is debatable, to engage directly with each other and seek to narrow the differences that they have at that point. Now, having that last step much earlier, I would think would avoid an awful lot of those meanderings, if that's the right expression, and cut down a lot of the expense, the time involved in considering an incomplete picture. And then you get to the heart of the differences between the experts. And I do honestly believe that two experts challenging each other, genuinely challenging each other's opinion, is much more efficient than a tribunal appointed expert having questions posed from the shadows by people that are not engaging directly with him. And then, of course, there is the whole question of where does a tribunal get an expert? Where do you find these people? Who accredits them? Who regulates them? So where I have been involved in civil law jurisdictions where the norm is for the courts to appoint, they tend to appoint, my experience, they tend to appoint people that haven't been in practice or on industry for 30, 40 years. They tend to be professors at a university that once worked in industry a couple of decades ago. So you're not engaging with people who are current. You're not necessarily engaging with the best experts because there are huge constraints, particularly in a court-appointed position, in terms of fees that those experts will be paid. There are a whole lot of downsides to tribunal-appointed experts that I don't think have come through necessarily as loudly as the complaints of party-appointed experts. But I do genuinely believe that the perceived difficulties with party-appointed experts are perfectly capable of being managed if they are managed by the tribunal early. And I think a part of that process, when we come to joint expert reports, that really becomes key. You know, my experience is that once you get to the point where the experts engage, genuinely engage to seek to narrow differences, which they may not achieve, but what you achieve irrespective is a statement of why they cannot agree. And that's astonishingly important. You then end up with a joint statement that acts almost as a lens through which the tribunal can view the experts' respective positions, the reasons for them, and importantly, the reasons why they differ. You know, and I have found that interestingly, where the experts agree on a joint statement, very rarely does that even get mentioned at the hearing. You know, that lens almost becomes a focus to narrow what needs to be addressed within the hearing process, which is a very expensive process for the parties. You know, now there are questions to that, obviously, in as much as is that the tribunal obfuscating their responsibility and passing it back to experts to settle for them. I have had a conversation with instructing counsel because when it first happened in an arbitration in Singapore, actually, and they were large issues with lots of money attached to them, then the issue was why that particular party's counsel did not want to talk about it. And the response was they didn't want to upset the tribunal because the tribunal didn't want to know. And I find that actually quite interesting. I mean, if I just very quickly touch on hot tubbing, I appreciate I'm talking far too much.
Sure. Let's do them all in a package and then hear from Aaron. Okay.
Hot tubbing of experts, it's basically become fairly standard, albeit every tribunal seems to have its own version. What I see quite commonly now is a combined approach where you will actually have questioning, kind of shortened form of cross-examination, witness conferencing, questions from the tribunal. And that works well if it is well structured and well pre-prepared. So again, I had a case in Maxwell Chambers that I was involved in whereby it's the best hot tubbing that I have ever seen done. Essentially, the tribunal had read all of the papers. One of the tribunal members was appointed to lead that entire session. And what he did was he brought the experts in 3 days before, and he handed them a list of questions. And he said, this is what I am interested in hearing about. These are the things I want answers to. And those questions were then put to each of the experts in turn, and the experts then engaged in a discussion around that particular subject area. The tribunal asked additional questions and then allowed the lawyers present to ask what they liked at that point. And that whole process actually worked tremendously well.
How long did that process take? How long did the hot tubbing in the actual hearing take? How many hours?
It took a day to do delay, and it took 3/4 of a day to do quantum. But it was a complex dispute.
Sure. One final question before we go to Aaron. When you have joint expert reports, or alternatively in the last scenario that you provided when the tribunal met with the experts, gave them questions, what, if anything, is counsel's role? Do counsel get to review their respective experts, party-appointed experts' responses to the joint expert report or to the tribunal's questions, or don't they?
That's actually quite an interesting point. As far as the joint statement is concerned, my experience, normally the lawyers are not involved. You have some lawyers that want to be involved, and that can be difficult because I've had a practice that has come and said, we would like you to insert this, 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 and this into the joint. And my response to that was, well, those are either factual issues or legal issues. They are not for this joint statement. And that was accepted, which was fine, but I can imagine perhaps a different set of lawyers might be more insistent. It's obvious when you're engaging that you send a draft to the other expert and you hear nothing for days. And the reason you hear nothing for days is he's being told what to respond. That is very frustrating. You know, if there is a genuine engagement and if there is a genuine difference of opinion and a good reason for that, then you would expect that to naturally flow and be expressed. So if that process is without prejudice, then I do not believe that you should be passing all of that out with that circle whilst you are in that process. Personally, I have no real difficulty once you get to a point of agreement, just to have someone run an eye over it before it is signed. You know, if somebody wants to challenge why I think that is appropriate, I'm happy to explain that. I know that other law practices have a completely different view. Most that I have engaged by are quite happy to just stand back and leave you to it and actually think they should not be involved. But there are practices that clearly think that they should have a role and they should have a fairly robust involvement in that. I'm not convinced that that's actually the process.
Sure. I mean, but let's go to Aaron next. There is an argument that there be transparency in that process, that counsel be told what their role is, so that both sides, in a sense, are on a level playing field with respect to access to experts and involvement in joint expert work product. But Aaron, from the council side, your thoughts on all of these issues: tribunal appointed experts, joint expert reports, hot tubbing, any aspect of the expert process.
I think I have a 2-minute allocation, so I may not hit everyone, but I'll tell you what I feel passionately about. With tribunal appointed experts, I think there's 2 instances where it makes sense to have them. So one of them, if you have a case with, say, 400 disputed variations, you're usually going to have about 150 of them that are really big and really matter. The rest of them, all taken together, equals a lot of money, but may not be worth, 2 experts opining on them and counsel making submissions on them. So if for what we affectionately call them the rats and mice claims, if you can agree a tribunal appointed expert to look at those on the papers with, a very short submission, 1-2 pages hitting the high points, then that can be effective for everybody. It's a real win-win to look at them that way. Another instance is, not in arbitrations involving the present company, but in some of the cases where I've been an arbitrator, people have obviously overestimated my competency and knowledge of things and haven't made submissions on things I don't actually know anything about, but I need to make a decision on. So there may be cases like that. If nobody on the tribunal has any idea about the governing law, you might need a tribunal appointed expert to assist you with that. I do think a number of the things that were mentioned yesterday by Doug Jones are very sensible. There does have to be parity of information between the experts. If you're talking off 2 different sets of information, you're not going to come to any form of useful agreement. Similarly, if you've gotten instructions to do totally different things, that's not going to help either. In terms of joint expert meetings, I think that should be left to the experts generally, especially if you've got, experienced delay or quantum experts. A little bit more cautious if you have an engineer that's, a really subject matter expertise, but isn't an experienced testifying expert and isn't going to know what to do when he finds himself in a proxy fight with somebody who's being managed by another law firm. So I usually try and just check in with those experts a bit more as it's going on. I mean, one of the times I had a call from someone saying, he's asking me to agree this, but neither one of us know what the statement means. I think he got it from his lawyer. So you do need to look out for those. But generally with professional experts, they can come to their own agreements. You'll usually just want to take a look at the end to make sure that they've not gone off and made an opinion of law or something else that they're not an expert in. Usually we get more used as a grammar spell checker, to be honest, rather than actually changing the opinions.
No doubt at equivalent hourly rates. We have 10 minutes now, actually 8 minutes for Q&A, for questions from the audience. Unless because all the panelists have been so generous with their time, anyone has any concluding observation, something they wanted to say, but because of my ineptness as a moderator, they didn't get a chance to say. Any concluding observations before we turn to questions from the attendees? Hassan.
Well, Gary, actually, many thanks. I would like, I have one point which is attached to the 2 points, one raised by Tom with regards to the consolidation and bifurcation. So the same incident will touch base on both points.
Sure.
With a recent decision by the Dubai Court of Appeal. As you know, actually, we have a lack of provision dealing with the consolidation, whether in the federal law, as well as some of the institutions here. The decision actually was relating to an arbitral award issued to dismiss the case due to the lack of jurisdiction. And the decision actually was a final decision. It wasn't an interim decision by the tribunal. So that the tribunal found that the challenge raised before them, they decided to dismiss based on the lack of the jurisdiction for two issues. One is that both parties, they didn't attempt to settle the matter. It's a construction dispute, while the clause has the pre-condition. The other challenge, which is very important, it was the claimant was trying to bring 6 subcontractors and consolidate them in order to present them before the tribunal. So the tribunal said, sorry, we cannot do this because we don't have actually any support by the federal law and the institutional rules. The party who basically was challenging this, he took the case or the award to the Dubai Court of Appeal, and he was trying to annul the decision by the tribunal. The Court of Appeal actually, and this is the good point and a positive point, they decided to annul the award. And they clearly mentioned, although actually we don't have any provision within the federal law, and institutional rules doesn't contain the provision dealing with the consolidation, but you as a tribunal were supposed to look, since the arbitration is seated in UAE, you were supposed to look at the other laws. And we have the consolidation method within the civil procedure law. And it was so possible for you to consolidate if the conditions are there. This is, I believe, actually, it gives us a lot of positive things, actually, that the court trying to help and be supportive to the arbitration. But at the same time, actually, when we are talking about the bifurcation, it was so easy for the tribunal to decide at the beginning with the challenge related to the to their jurisdiction, rather than keeping it towards the end in terms of the cost and the time, actually.
It's a fascinating decision by the local court. It'd be worth circulating that to the participants. We have, I think, 3 minutes at this point to do Q&A. One of the questions coming from an attendee is a client has an uncitral arbitration clause. Good thing, bad thing, or indifferent thing? What are the panelists' views about an ad hoc arbitration provision like the uncitral clause versus an institutional arbitration provision, completely neutrally, for example, an SIC arbitration clause? Who wants to volunteer for that? Aaron, you look like you were about to raise your hand.
You know, I wasn't. I think uncitral rules and uncitral provisions can be fine. I think sometimes it can be helped if it's uncitral rules administered by a particular institution in case you get into a snarl. Generally, ad hoc can be difficult in a number of ways. For example, if you have a tribunal that's set a fee deal, requires payment up front, and then decides not to perform, what are you going to do? Much more difficult in ad hoc. You get protections from institutions and help. You can call them and ask what to do in a difficult situation, and part of their job is to make sure that things operate on time. So no issue with the rules, but having an administering institution is helpful.
Gao Kai, just very quickly, your thoughts on the same topic. We'll turn to Tom, and then I think we're finished.
I think I have to agree. I mean, it's probably an advertisement for SIC, but you know, SIC actually has a practice note for administering arbitrations under uncitral rules. So I think there's a lot more benefit if you know it is administered by an institution.
Yep. And Tom, finally, one last word from you.
Completely agree. 9 times out of 10, probably 99 times out of 100, institutional arbitration is better. Pick the right institution. Pick an experienced one, a reputable one. The other thing with the ad hoc arbitrations, sometimes you get things you don't expect. So for example, if you have an ad hoc arbitration seated here in Dubai, let's say you're an international company relatively new to the region, the default language of the arbitration will be Arabic rather than English. So that could be a surprise to say, a foreign investor.
That's all very, very helpful. One final question, which I'll take care of before we say goodbye. What do you do about a non-responding respondent? A defaulting respondent is one of the questions from our participants. The very short answer is most institutional rules, certainly the SIC rules, give the tribunal the power. National law affirms that authority to go forward and make an award against a default award against a non-participating respondent. That award is an award like other awards that are made by the tribunal and is fully enforceable under both the New York Convention and national arbitration legislation. A party defaults in international arbitration at its own peril. With that, it's only for me to say thank you, a heartfelt thanks from SIC to all of our panelists who did tremendous work under great time pressure today. Thanks also to our attendees for staying with us, and we look forward, as Siac said at the outset, to this being a beginning, not an end, the beginning of a long-term cooperation with the Dubai, the regional international arbitration community. Thank you again.
Thank you.
Thank you.
Thank you.
Thank you all. Thank you to all speakers for the insightful discussion. That concludes this SIAC webinar. We hope you have enjoyed it very much. Have a great afternoon.